Hello everyone, welcome to your Lordships revised through MCQ series, and again today we are going to discuss the multiple choice questions that are asked in prelims examinations of judiciary, and today we are going to discuss the Bharatiya Nagarik Suraksha Sanhita or the Code of Criminal Procedure. So as we all know that now the Bharatiya Nagarik Suraksha Sanhita 2023 has replaced CrPC. So what kind of questions may be asked? Let's see. So the first question is, who among the following is not entitled to claim maintenance under section 125 CrPC? So this question has been asked in UP Judiciary 2016. Who among the following is not entitled to claim maintenance under section 125 of CrPC? And the options are divorced wife so long as she does not remarry, unmarried sister, adoptive mother, illegitimate minor child. Let's see the answer. What is the answer of this question? And the answer is unmarried sister. So unmarried sister category is not given in section 125 CrPC. So answer is B, and see the explanation. What is the justification of this answer? So 125 CrPC says clause 1, if any person having sufficient means neglects or refuses to maintain his wife, illegitimate minor child, illegitimate child not being a married daughter, or his father or mother. So unmarried sister category is not there. Let's see the next question. Question number 2 is, under which one of the following sections of the Criminal Procedure Code monthly allowances or the interim monthly allowances for maintenance can be altered? Again, it has been asked in UP Judiciary 2018, and the options are section 125, 126, 127, 128. And the option is C, that is section 127. In 127, monthly allowances and their interim monthly allowances for maintenance can be altered. So let's see the justification. What is given? So 127 provides that on proof of change in the circumstances of any person receiving under section 125 of monthly allowances for the maintenance or interim maintenance, or ordered under the same section to pay a monthly allowances for the maintenance. So this is given in 127. Let's see the next question. Question number 3. No wife shall be entitled to receive maintenance from her husband under section 125 of CrPC 1973 if this question has been asked in West Bengal Judicial Services 2023 only, and the options are if she has obtained a divorce from her husband and has not remarried, if she is unable to maintain herself, if she refused to live with her husband on the ground that keeps a mistress, if she is living in adultery. So these are 4 options where the wife is not entitled to maintenance. Now see the answer, and the answer is if she is living in adultery. So if she is living in adultery, she cannot claim the maintenance. And what is the justification? Let's see. The justification is clause 4 of section 125 CrPC, which says no wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and the expenses of the proceedings, as the case may be, from her husband under this section if she is living in adultery. So that is given in the section itself. Now section 125 has been renumbered as section 144 of Bharatiya Nagarik Suraksha Sanhita. Let's see the next question. The next question is, evidence in proceedings of 125 of the Code of Criminal Procedure 1973 shall be recorded in the manner. Again, this has been asked in RJS 2021, and you all know that RJS is going to be conducted now. So this question has been asked that evidence in proceedings of 125 of the Code of Criminal Procedure shall be recorded in the manner, and the options are prescribed for summons cases, prescribed for warrant cases, as prescribed by the court in its discretion, prescribed for the summary trials. Let's see the answer, and the answer is A, that is prescribed for summons cases, right? And what is the justification? Where is it given? Let's see where is it given. So this is given in section 126 of CrPC, which has now become section 145 of BNSS. 126 CrPC clause 2 says that all evidence in such proceeding shall be taken in presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with in the presence of his pleader, and shall be recorded in the manner prescribed for summons cases. So this is given in the section itself. Let's see the next question. The next question is, landmark judgment in the case of Muhammad Ahmad Khan versus Shah Banu Begum and others in 1985 Supreme Court was pronounced. This has been asked in Himachal Pradesh Judicial Services 2023 by Chief Justice Y.V. Chanchud, Chief Justice J.P.N. Bhagwati, Justice J.M. Hamidullah Beg, Justice Sabyasachi Mukherjee. Now see the answer. So it is at that time Chief Justice Y.V. Chanchud. So this is given in the case only that Justice Y.V. Chanchud held that Muslim divorced women is entitled to claim maintenance under section 125 of CrPC. Let's see the next question. The next question is, who of the following may order for maintenance of wives, children and parents under CrPC 1973? Again, this has been asked in Uttarakhand Judicial Services. See the options only: executive magistrate, judicial magistrate second class, judicial magistrate first class, all of the above. See the answer. Answer is magistrate of first class, that is judicial magistrate first class. Where is it given? So this is given in section 125 only, and if you see in first clause D, that magistrate of first class may, upon the proof of such neglect or refusal, order such person to make a monthly allowance. So option is very clear that magistrate of first class can order maintenance under section 125. Now there are certain proposed questions on the recent judgments which might be asked in your upcoming prelims examinations of RJS, Uttarakhand and any other examination. In which of the following recent Supreme Court judgment was it held that a divorced Muslim woman can seek maintenance under section 125 CrPC, and that the Muslim Women Protection of Rights on Divorce Act 1986 is not in derogation but in addition to section 125? We are talking about a recent judgment. Muhammad Ahmad Khan versus Union of India 2024, Muhammad Altaf versus Union of India 2024, Muhammad Abdul Samad versus State of Telangana 2024, none of the above. See the answer. It is Muhammad Abdul Samad versus State of Telangana and others 2024. So this is a recent judgment which reiterated the judgment of Shah Banu Begum. So answer is Muhammad Abdul Samad versus State of Telangana 2024, and there it is given. Supreme Court held that 125 is applicable to all Muslim women. So this question might be asked. There are certain proposed questions on BNSS 2023. Now the question is, under which chapter of Bharatiya Nagarik Suraksha Sanhita 2023 is the provision for order for maintenance of wives, children and parents laid down? So they are asking which chapter. What is the chapter number, whether it is 9, 10, 11 or 8? And the answer is chapter 10. So in BNSS, the order for the maintenance of wives, children and parents are given under chapter 10 of BNSS. So this might be asked in your prelims examinations. Next question is, under which section of Bharatiya Nagarik Suraksha Sanhita is the provision for alteration in allowances maintenance dealt with? Section 143, 146, 147, 149. I have told you that section 125 has now become section 144. So let's see that where is the alteration in allowance given. So the answer is section 146 of BNSS. So it is given directly 146 BNSS, where upon the change of circumstances, the court may alter the maintenance. And the next question is, period of limitation for execution of the order of maintenance under section 144 of BNSS is? What is the period of limitation? That might be asked in your prelims exam. 1 year from the date on which it becomes due, 3 years from the date on which it becomes due, 5 years from the date on which it becomes due, 12 years from the date on which it becomes due. And the answer is 1 year from the date on which it becomes due. That is option A, and it is given. The justification is section 144 of BNSS, where the proviso to clause 3 says, provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. So within a period of 1 year, you have to claim. So limitation is 1 year from the date when it becomes due. So for more such questions, kindly subscribe our channel, Your Lordship, and kindly contact our channel on the given details. And friends, we are also starting with the RGS crash course from 25th of June and the special Hindi classes from 1st of July 2025, especially for those who are appearing for RGS examinations. Thank you so much.